Hi, my name is Christina Loback, and today we are discussing how to overcome a finding of inadmissibility in Canadian immigration law. In a nutshell, inadmissibility means that a person has been found to be inadmissible. They are barred from entering Canada. A person who is criminally inadmissible is not allowed to enter or stay in Canada because they have committed or been convicted of a crime for which they have not received a record suspension, which we used to call a pardon, or they haven't been rehabilitated under the Immigration and Refugee Protection Act. If the crime was committed within Canada, the only way to overcome inadmissibility is to apply for a record suspension with the Parole Board of Canada. In order to be eligible, you must have completed all of your sentences and fines, which includes things like surcharges, costs, restitution, and compensation orders. They must all be paid in full. All sentences of imprisonment and conditional sentences, including parole and statutory release, must be completed. In addition, any term of probation must also have concluded. You must also have completed the appropriate waiting period, which is based on when you committed the first offense, and it also depends on whether the offense you were committed of was prosecuted summarily or if it was an indictable offense. Now, what if you received a record suspension or a discharge for your conviction in another country? Well, the best bet is to check with the visa office that serves the country or region where you live. The visa office can provide you with guidance on whether that pardon is going to be valid in Canada, which is based on a three-pronged test. Okay, so what if the crime was committed outside of Canada and you don't have a foreign pardon that is recognized by Canada? That's when you consider whether you may be deemed rehabilitated or if you need to file an application for criminal rehabilitation. You're always going to want to check first if you can be deemed rehabilitated. Deemed rehabilitation means that enough time has passed since you were convicted that your crime may no longer bar you from entering Canada. Whether you may be deemed rehabilitated depends on a few factors. So first, the amount of time that has passed since you completed the sentence imposed for your crime. So if you have one indictable offense, the waiting period is 10 years. If you have two or more summary convictions, the waiting period is going to be 5 years. Second is the crime you committed. The crime itself must not be considered one with serious criminality attached, and the crime must not have involved any serious property damage, physical harm to any person, or any type of weapon. And then third, how many crimes you committed. So if you only had one indictable conviction in total, or you committed only one indictable crime, you'll be eligible for deemed rehabilitation. Also, you have to consider if the crime was one of general criminality or serious criminality. Now, if you qualify for deemed rehabilitation, there's no formal application per se. You are rehabilitated and that status is deemed. Those living outside of the United States should seek an assessment from a visa office or consulate first. If you live in the US, you can travel to a Canadian port of entry and ask to be assessed for rehabilitation by the border officer. The process for assessment at a port of entry is totally different from assessment by a visa office. If you're not deemed rehabilitated, you will have to apply for criminal rehabilitation. If you were convicted of an offense with serious criminality, let me just save you some time and tell you right now, you will not be eligible for deemed rehabilitation. Criminal rehabilitation means that the minister or their delegate believes that you're not likely to be involved in any further criminal activity. So in order to apply, you must demonstrate that you meet the criteria, that you've been rehabilitated, and that you are highly unlikely to take part in any further crimes. You are eligible to apply for rehabilitation if you have committed an act outside of Canada and 5 years have elapsed since the act, or you were convicted outside of Canada and 5 years have passed since the end of the sentence imposed. Remember, if the crime was committed in Canada, you have to get a record suspension. So a criminal rehabilitation application will typically take at least 6 months for the government to process. The decisions are highly subjective, and it's really important to present the most compelling application possible. Now, what if you aren't eligible to apply for rehabilitation, you aren't eligible for deemed rehabilitation, and you aren't eligible for a record suspension? There is a mechanism to request special permission to enter or remain in Canada, a temporary resident permit. To be eligible, your need to enter or stay in Canada must outweigh the health or safety risks to Canadian society. Most people apply through a TRP through the Canadian consulate, but US citizens have the option of applying for the TRP directly at a Canadian port of entry. It's usually issued for the length of your visit to Canada and is no longer valid once you leave Canada unless you've been specifically authorized to leave and re-enter. Individuals who've been convicted of crimes with serious criminality, including impaired driving, are eligible to apply for a temporary resident permit in order to temporarily enter Canada. If you have any questions about this, feel free to reach out to us.